Imagine spending your whole life paying off your home only to have it trigger family conflict, tax problems, or even a lawsuit because of one estate planning tool that most people don't fully understand. Transfer on death deeds sounds simple. They avoid probate. They seem really clean, but they can also accidentally disinherit grandchildren, expose your home to your child's creditors, or create massive fights between your beneficiaries. I'm Guy Martino, an Indiana estate planning and probate attorney, and today we're talking about the hidden risks of transfer on death deeds and when they work beautifully. Let's dive in. A transfer on death deed lets you name a beneficiary for your house, just like naming a beneficiary on a bank account or on a retirement account or any other account that you may have. While you're alive, nothing changes. You keep full control. You can sell the house. You can refinance it. You can revoke the transfer on death deed. And when you pass away, your home transfers without probate. That sounds perfect, doesn't it? Well, yes and no. Let's talk about the benefits first. Benefit number one, it avoids probate. For many families, their house is the only probatable asset. Everything else, retirement accounts, bank accounts, life insurance, already avoids probate with beneficiary designations. So one TOD deed can save thousands of dollars and months of delay. Benefit number two, you have full control while you're alive. Unlike adding a child to your deed, which can cause tax and creditor issues, transfer on death deeds give beneficiaries no ownership until you pass away. You stay in complete control. Number three, it preserves stepped-up basis. This is a major tax benefit. Your beneficiaries will inherit the home at its market value on the date of death. So if they sell it immediately, they owe little to no capital gains tax on the home. Transfer on death deeds preserve this advantage just like a living trust. Now let's talk about a few of the risks with a transfer on death deed. There are very powerful tools, but they can also create major problems if used in the wrong situation. Here are the biggest risks. The first risk, multiple beneficiaries become co-owners of this property. So if you name multiple kids, they instantly become co-owners. This leads to real-life issues. One wants to sell immediately. One wants to keep the house. One wants to sell it to a family friend at a discounted rate. I've seen families end up in expensive partition lawsuits because of these situations. Trusts avoid this because the trustee, not the beneficiaries, controls the property and how the property can be disposed. Risk number two, you must distribute equally. Transfer on death deeds cannot give different percentages to different beneficiaries. If one child provided years of care, you may want them to receive more, and a transfer on death deed cannot do that, cannot accomplish what you want. Trusts allow complete distribution flexibility. You can give one kid a third, one kid 50%, and whatever's left over to your third child. You can do it however you want with a trust. The third risk associated with transfer on death deeds is, what if a beneficiary dies first? This is common. It's a heartbreaking issue, but if a child dies before you, one of two things can happen. Outcome A, their share is split among surviving children, disinheriting your grandkids that came down that line. Outcome B, beneficiaries disagree and it has to go to probate anyway. Outcome C, you have the right language in the transfer of death, and the benefit for the deceased child goes down to their children, but then you now might have three children on that side owning 1/3 of the property, and then your other two kids owning 2/3 of the property, and that can cause some strife between families. Trusts do prevent accidental disinheritance or problems if you start to get deeper into grandkids where you might have more of them. So you might end up, if you live a long life, you might end up having 10 owners of one piece of property, which can cause a problem. Risk number 4, beneficiaries' creditors can reach the house once it's transferred to them. If your beneficiaries have debts, lawsuits, divorces, or bankruptcies, creditors can go ahead and attempt to place a lien on the inherited property. Then the other co-owners of the property are going to have to deal with those issues. And since all beneficiaries co-own the home, one person's financial trouble can become everyone's problem. Trusts provide far stronger protection for creditors. Risk number 5, a TOD does nothing for incapacity. A transfer on death deed, you hear the word there, death, only works after death. So if you become incapacitated, if you lose your mind, the deed does nothing. You still need a power of attorney, and a trust provides even better incapacity planning should something happen where you can't take care of yourself physically or mentally. Risk number 6, you forget to record the deed. If it's not recorded, it doesn't exist. I've seen this a few times. Someone signs a TOD but never records it. If it's not recorded before death, it's invalid. You can't go ahead and record it after death. And the family will end up in a probate matter anyway if this happens. When these deeds work well, they really work. And there are certain situations in which they are really ideal for. Let me give you a few scenarios. A retiree with one home and one adult child. A widow with a house and one heir. A bachelor leaving property to a niece or to a grandchild, a divorced parent with 2 mature, responsible adult children that get along. In simple estates, they can save time and they can save money. When TOD deeds are not a good fit, though, is when you have multiple beneficiaries, people who do not get along, blended families, when you want to give an unequal distribution to your heirs, when your beneficiaries might have problems with alcohol or drugs or creditor issues, if the property is a rental property, if you have firearms or a business, if you have real estate in multiple states, or if you need incapacity planning. Transfer on death deeds just do not work in these types of scenarios. In these situations, a living trust is far more safer and far more flexible, and you will be able to set down the rules for orderly distribution of your property after you pass away. Now that you understand the pros and cons of a transfer on death deed, your next question probably is, when is a revocable living trust the better choice? In the next video, I'll walk you through that exactly. Click over now to the video titled Indiana Revocable versus Irrevocable Trust, which is better? I'm Guy DiMartino, and I'll see you over there. Have a great day.